Picture this scenario. You are 74 years old. You have lived in your home for 32 years. You paid it off completely. You raised your children within those walls. You put your own hands to work painting every single room. Every corner of that house holds a piece of who you are. Then one Tuesday morning, your heart gives out. Not fatally, you make it through. But when you open your eyes in that hospital bed, you cannot speak. You cannot write. You cannot put your signature on anything. Your daughter rushes straight to your bank to cover your property taxes before the due date. She walks through the door. She gives them your name. She explains the situation. And the bank responds with this: "We are sorry. You have no legal authority over this account. She cannot pay your outstanding bills. She cannot touch your accounts. She cannot keep your home maintained. She cannot make a single decision on your behalf." And while she stands there with nowhere to turn, the bills keep arriving. This is not a scenario I fabricated. According to the Consumer Financial Protection Bureau, the CFPB, this plays out for American families every single day. Not because anything went wrong with the system, but because 5 straightforward documents were never completed. My name is Diane. I am a senior policy analyst with a focus on retirement finance, Social Security regulations, and the legal protections built specifically for people over 60. Today, I am going to walk you through the 5 most essential documents every homeowner over 60 absolutely must have in place in 2026 before anything goes wrong. Every piece of information I share comes directly from official sources: the CFPB, Medicare.gov, the IRS, the Social Security Administration, and verified AARP research. No personal opinions, no internet speculation. And before we move forward, stay with me until document number 5, because I am going to walk you through a hidden IRS tax trap that could strip your children of hundreds of thousands of dollars in capital gains taxes. It all hinges on one single decision you make about your home while you are still living. The vast majority of seniors are completely unaware this trap exists. By the end of this video, you will be. Let me tell you about Robert. Robert was 68 years old, a retired electrician from Ohio. He owned his home outright. He had his pension, his monthly Social Security payment, and a modest savings account. He thought of himself as a responsible man. Over Thanksgiving dinner in 2024, he sat down with his 2 adult children and spelled out exactly what he intended. His house would go to his daughter Karen, since she lived close by. His savings would go to his son David, clean, fair, and straightforward. Everyone listened, everyone agreed, but Robert never put any of it in writing. He never signed a will. He never filed a power of attorney. He trusted that his children understood his wishes, and he believed that was sufficient. Then, in early 2025, Robert suffered a serious fall. He developed a brain bleed that left him incapable of making his own decisions. Karen went to his bank to pay the property taxes. She was turned away at the counter. She contacted Social Security to manage his incoming benefits. They informed her she had no authority to do so. She attempted to arrange repairs to the home so Robert might eventually return from rehabilitation, but she could not legally sign a single agreement. David retained an attorney and filed a petition with the court for guardianship. Almost immediately, Karen and David were no longer aligned. The court became involved. Legal expenses began accumulating rapidly. Robert's house sat empty for 11 months. Property taxes went unpaid. A lien was placed against the property. 11 months with no authority and no plan in place. The home nearly slipped away entirely. Every single element of that situation could have been stopped before it started if Robert had filed 5 documents. Let me walk you through what those documents are. Document number 1 is the Durable Financial Power of Attorney. This is the single most critical legal document for any homeowner who is over 60. A Durable Financial Power of Attorney, commonly referred to as a POA, grants someone you trust the legal right to make financial decisions on your behalf if you are ever rendered incapacitated. That individual is called your agent. Their authority is broad. It covers paying your mortgage, managing your bank accounts, dealing with property taxes, and even selling your home if that ever becomes necessary. Now pay very careful attention to the word durable. According to the Consumer Financial Protection Bureau, a standard power of attorney actually ceases to function the moment you become incapacitated. That is precisely the moment when you need it most. A durable power of attorney continues to remain valid even after you have lost the capacity to make your own decisions. That one word, durable, changes everything. Here is the trap that catches most seniors completely off guard. A large number of people assume that a spouse or an adult child can automatically step in and take over the finances when needed. The CFPB is unambiguous on this point. That assumption is wrong. Without a valid, durable POA on file, no family member has any legal authority to act on your behalf. Not your wife or husband, not your son or daughter. Without this document in place, your family has exactly one available option: petitioning a court for guardianship or conservatorship. The CFPB describes this process as lengthy, expensive, and highly public. AARP has reported that conservatorship proceedings frequently lead to serious family conflict, competing legal petitions, and ultimately the court rather than your own family deciding who takes control of your life. There is one more critically important thing to understand here. The Social Security Administration now offers something called the Advanced Designation of Representative Payee. This allows you to identify up to 3 people who could be authorized to manage your Social Security benefits if you ever become unable to do so yourself. You can complete this designation right now at no cost through your My Social Security account at aesa.gov. I strongly encourage you to do this today, rather than putting it off. Document number 2 is your last will and testament. And I do not mean just any will. I mean one that specifically and clearly addresses what is to happen with your home. According to the Consumer Financial Protection Bureau's official guide for older Americans, a will is the legal document that expresses your intentions for what becomes of your property when you pass away, including your house. Here is the misconception I encounter constantly. Seniors believe that verbally communicating their wishes to family members is sufficient. It is not. Without a valid written will, your home is distributed according to your state's intestacy laws. That means the state, not you, determines who inherits your house, and the state's formula may direct your property to someone you had no intention of leaving it to. AARP states it plainly. Without a will, the outcome is left to state law and probate courts, which can result in unnecessary delays, significant expense, and what AARP describes as tangled titles. A tangled title means that the individual living in the home is not recognized as its legal owner. They cannot sell the property. They cannot refinance it. They cannot even obtain proper insurance coverage for it. In certain cases, they are unable to authorize even basic repairs. And here is what this costs in practical terms. AARP estimates that going through probate without a will can take more than a full year and consume more than 3% of the total estate value. On a home valued at $350,000, that comes to more than $10,000 that your family loses simply in probate-related fees. If you already have a will, pull it out right now and check when it was written. If it predates a divorce, the death of a family member, or the birth of a grandchild, it likely needs to be revisited and updated. Free legal assistance is available for individuals over 60 through the Elder Care Locator. You can reach them at 1-800-677-11116. That service is federally funded and connects you with no-cost legal help right in your area. Document number 3 is the one most seniors have genuinely never heard of, and it may very well be the most powerful tool on this entire list. A transfer on death deed, also called a TOD deed, is a legal document that directs your home to pass directly to the person you designate when you die. No probate process, no court involvement, no waiting period, no legal fees. According to the CFPB, it is simpler to establish and far less expensive than setting up a trust. As of 2026, approximately 30 states plus Washington, D.C. permit TOD deeds. You file it with your local recorder of deeds office. You retain complete control over your home for the entirety of your life. You can modify or revoke it at any time. If you reside in a state that does not permit a TOD deed, the available alternative is a revocable living trust. According to consumerfinance.gov, a living trust allows you to transfer your home into a trust structure that you personally control throughout your lifetime. You serve as your own trustee. When you pass away or become incapacitated, a successor trustee you have already designated steps in and manages the transition, again without the need for probate court. But here is the critical trap that so many people fall into. Many individuals establish a living trust and walk away assuming the job is finished. It is not. The CFPB is very specific on this point. A living trust does not accomplish anything until your property is actually transferred into it. That means you must retitle your home in the name of the trust itself. If you skip that step, your home will still pass through probate even if you paid an attorney to create the trust. One additional warning to keep in mind. The CFPB cautions that living trusts are sometimes actively marketed by unscrupulous companies. If anyone approaches you and offers to establish a trust at a suspiciously low price, verify their credentials thoroughly and consult with an independent attorney before agreeing to anything. Document number 4 protects your physical well-being rather than your financial accounts. According to Medicare.gov, an advanced healthcare directive consists of 2 distinct components. The first is a healthcare proxy, sometimes referred to as a durable power of attorney for healthcare. This designates a trusted individual to make medical decisions for you if you are ever unable to communicate those decisions yourself. The second component is a living will. This document describes which medical treatments you wish to receive or decline if your life is at risk. We are talking specifically about interventions such as dialysis, mechanical ventilation, resuscitation efforts, and feeding tubes. It also captures your preferences regarding organ donation. Here is a trap that catches many seniors off guard. A significant number of people believe their financial power of attorney also extends to medical decisions. It does not. The CFPB makes this distinction very clearly. A financial POA and a healthcare directive are 2 entirely separate documents serving 2 entirely different purposes. You need both of them in place. And here is another mistake people frequently make. They go through the process of creating the directive and then place it in a filing cabinet without telling anyone where it is. If no one can locate your directive during a medical emergency, it is effectively the same as never having created it. You need to provide copies to your physician, your hospital, your designated healthcare proxy, and at least one other trusted family member. Here is a piece of genuinely encouraging news. Medicare covers conversations about advanced care planning at no additional cost to you when they occur as part of your annual wellness visit. The next time you see your doctor for your yearly checkup, raise this topic. Ask for their assistance in documenting your wishes in a formal and binding way. Medicare.gov explicitly states that you have the right to carry out your personal plans as you choose, free from any form of discrimination. AARP has reported that the absence of a healthcare directive is one of the primary reasons families find themselves drawn into conservatorship proceedings. Do not put your loved ones through that experience. Document number 5 saves you money on an ongoing annual basis and contains the hidden tax trap I mentioned at the very beginning of this video. Give this your full attention. First, the opportunity for real savings. Most states and a significant number of cities offer homestead exemptions or senior property tax exemption programs. These programs reduce the assessed taxable value of your home, which in turn meaningfully lowers your annual property tax bill. Some states go further and offer tax freeze programs that put a ceiling on how much your property taxes are permitted to increase from one year to the next. But here is what catches people entirely unprepared. These exemptions are not applied automatically. AARP is very direct about this. You are required to submit an application to your local county assessor or tax office. And in many jurisdictions, you must renew that application every year or every few years to keep the exemption active. One expert cited by AARP put it in plain terms. Anyone can forget to complete the renewal paperwork, particularly older adults who receive a steady stream of mail. If you miss the filing deadline, you pay the full tax rate. And across 10 or 20 years of retirement, that can translate into tens of thousands of dollars lost unnecessarily. On the federal side, the IRS now provides Form 104 O-SR, a tax return format designed with seniors in mind that features larger print for easier reading. Beginning with the 2025 tax year, there is also a new enhanced standard deduction available to taxpayers who are 65 or older. And if you are considering selling your home at some point, keep in mind that according to IRS Publication 523, you may qualify to exclude up to $250,000 in capital gains from the proceeds of the sale. That exclusion rises to $500,000 for married couples filing jointly. The home simply needs to have served as your primary residence for at least 2 of the previous 5 years. Now, the hidden tax trap, and this is the one with the potential to cost your family the most significant amount of money. If you transfer your home to your child as a gift while you are still living, your child receives your original cost basis along with it. Let me translate that into real figures. Suppose you purchased your home for $60,000 40 years ago. Today, that same home is worth $400,000. If you gift it to your son today, his cost basis is $60,000. When he eventually sells that home, he will owe capital gains tax on $340,000. At a 20% capital gains rate, that works out to $68,000 handed directly to the IRS. But if you keep the home in your own name and he inherits it following your passing, something fundamentally different occurs. Under IRS Section 1014, the cost basis is stepped up to the fair market value of the property at the time of your death. This means his basis becomes $400,000. If he sells it at that same value, he owes absolutely nothing in capital gains taxes. That single decision, choosing to gift rather than allowing the property to be inherited, could be the difference between your child preserving their financial stability and losing tens of thousands of dollars to federal taxes. This information comes directly from IRS, Publication 551, and the IRS Gifts and Inheritances, FAQ page. Please consult a qualified tax professional before transferring your home to anyone for any reason. You now have a clear picture of all 5 documents. But understanding them without acting on them changes nothing at all. Here are 3 concrete steps I want you to complete this week. Not next month, not at some undefined point in the future. This week. Step 1. Gather and organise your 5 documents. Sit down at your kitchen table with a pen and a piece of paper. Go through this checklist carefully. Mark off what you already have. Circle what is missing. Number 1. Durable financial power of attorney. Number 2. Last will and testament with specific provisions addressing your home. Number 3. Transfer on death deed or revocable living trust. Number 4. Advanced healthcare directive, including a living will and a designated healthcare proxy. Number 5. Homestead or senior property tax exemption application. If even one of these is missing from your file, you have a gap in your protection. And gaps are what cost families their homes, their savings, and their sense of security. For any document you need assistance creating, contact the Eldercare Locator at 1-800-677-1116. This is a free, federally funded service for people over 60. That number once more, 1-800-677-1116. Step 2. Make sure the right people have copies of the right documents. Filing a document and locking it away in a drawer accomplishes very little on its own. Your durable power of attorney needs to be on file with your bank before any emergency occurs. The CFPB specifically warns that banks may decline to honour a POA they have never had the opportunity to review. Do not discover that problem in the middle of a crisis. Your advanced healthcare directive must be in the hands of your physician, your hospital, your designated healthcare proxy, and at least one other trusted member of your family. And log into your My Social Security account at ssa.gov today. Complete your advanced designation of representative payee. Name up to 3 people you trust with that responsibility. It costs nothing. It takes approximately 5 minutes, and it has the power to prevent an enormous amount of unnecessary suffering. Step 3. Schedule a review of all 5 documents once every year. Life evolves, relationships change, laws are updated. The person you named as your agent 5 years ago may no longer be the right individual for that role. Pick a date once a year, perhaps your birthday or the first day of January, and set aside time to review all 5 documents. Confirm they still accurately reflect your current wishes. Confirm the appropriate people have current copies. Confirm your property tax exemption application has been renewed if required. This single annual habit may be the most important thing you do to protect your home and your family's future. What I have shared with you today has the power to protect your home. It can spare your family from courtroom battles, unexpected tax burdens, and devastating financial loss. But the government is not going to send you a reminder when these rules shift. There is no automatic notification that appears when policies affecting seniors are updated. That is the exact reason this channel exists, to deliver real-time alerts whenever something changes in Social Security rules, Medicare policies, IRS regulations, or banking laws that directly affect people over 60. Click the link in the description right now. Subscribe, download your complimentary guide, and share this video with someone you care about who owns their home and is over 60. Because these 5 documents cannot help you after the crisis has already arrived. They only work when you have them filed before it happens. I am Diane. Thank you for being here and for watching.